Good evening, everyone. Thank you so much for waiting. It's wonderful to see you all here tonight. My name is David Kershaw. I'm Dean of LSE Law School. And it's a very wonderful evening tonight, I think, as we celebrate Lord Carnwath's 80th birthday. I think we can start with a birthday round of applause, don't you? Now, as you all know, Lord Carnwath has had an incredible career. Most importantly of all, of course, for us, is that he's a visiting professor in practice at LSE. But before then, as you all know, he was a Justice of the UK's Supreme Court between 2012 and 2020. Before that, an incredibly renowned and hugely respected High Court judge and then Court of Appeal judge. This is not an evening about company law. I'm a company lawyer, so it's always a bit of a shame, but one of my favourite judgments that I enjoy above all when I teach company law is one of Lord Carnwath's judgments, when he was causing a little bit of difficulty in the company law context, and it's a wonderful judgment. So it's an incredible thing to have Lord Carnwath speak to us tonight. He'll speak on law and the environment, A Judge Looks Back, and he'll speak to us for about half an hour. And then we're also really honoured tonight to have Mr. Justice Brian Preston from New South Wales, who is the Chief Judge of the Environmental Court in New South Wales. He's also a visiting professor at Durham and also a Vice President of the Global Judicial Institute on the Environment. Brian will speak to us for about 20 minutes, commenting on Lord Carnwath's talk tonight. Thank you, Brian, for being with us tonight. That's wonderful. And then finally, the floor will be held by my own colleague, Joanna Setzer. Where are you, Joanna? There you are. Fantastic. Dr. Joanna Setzer, who is a associate a professorial research fellow here at LSE in the Grantham Institute, and who also works very closely with us here in the law school. And she will chair the Q&A that I'm sure will be fantastic after the two talks. So, Lord Carnwath, the floor is yours.
Well, thank you very much, David. Thank you, and to the LSE and Grantham, and Joanna, who's sitting in front of me, who's been a tremendous support over the last few years. And this was, I'm afraid, her idea. And I was rather doubtful. It all happened when we were in China in December. We were there as a group of judges and academics. Brian was there as well, Brian Preston, invited by Client Earth, led by Dimitri de Boer, who's sitting over there, happily here, at a training conference for Chinese environmental judges, and hosted by the Supreme People's Court. Now, a lot of you probably don't realize how much environmental law has developed in China, and I'll be coming back to that. But it was at one of those sessions that we heard the result of the American presidential election. And it was a very curious feeling. There we were with 300 Chinese environmental judges discussing sort of climate change and the latest guidance from the Supreme People's Court about carbon neutrality. And when we heard that the other side of the world, the other world's biggest greenhouse gas emitter, had elected someone who was an outright climate change denier, and there was a sort of buzz around the room as all these judges were looking at their mobile phones trying to see what had happened. And some of them asked us, well, what did they think was going to happen as a result of this? And frankly, we didn't know. But talking about it afterwards, Joanna thought that things couldn't be quite as bad as we were worrying they might be. And we were talking, I don't know why she knew that my 80th birthday was coming up, but she somehow thought that would be an optimistic occasion, and that somehow, by the time we got to March, I'd be able to think of something optimistic to say in the light of what had been going on. So here we all are. And I'm not sure I'll do my best, Joanna, but we'll see how we get on. I mean, actually, at that time, I was reasonably hopeful that the new president might pull back from his promise to take USA out of the Paris Agreement, once again, as he had done back in 2017, because even the chief executive of ExxonMobil, Darren Woods, had been reported at the Baku COP29 conference in November as advising against withdrawal, partly because of the uncertain inefficiency caused by what he called having the pendulum swing back and forth as administrations change. And he thought it important for America to be playing an active role in the COP process, if only to protect its own interests. And in fact, the company's 2024 report, ExxonMobil's report, Advancing Climate Solutions, had gone further, citing addressing climate change as being one of the biggest challenges facing humankind right now and requiring unprecedented innovation and collaboration at an immense scale. Well, if that's the view of the chief executive of ExxonMobil, one thought the President of America might take some notice. But sadly, that was not to be. Hopes that sanity or even business common sense might prevail were rudely dashed. One of the new president's first acts was to start the process of removing US from the Paris Agreement. This was under an executive order bizarrely entitled Putting America First in International Environmental Agreements, as in environmental agreements, President, not out of environmental agreements. And then on the 4th of February 25, the Environmental Protection Agency's website greeted us with extracts from a Breitbart News interview with the new administrator, Lee Zeldin. He proudly announced that under the new president's, quote, "The EPA is going to aggressively pursue an agenda powering the great American comeback to return to its core mission of conservation and ditch the leftist environmental radicalism that has dominated in the past." There has been talk, he went on, through the years about how the world was imminently about to end because of climate change, and in the name of that threat, there was a push to do some crazy things. The timelines, he said, of those predictions of climate change ending the world have come and gone, and the world is still here. So that's all right, he said. And more recently, Zeldin announced what he called, quotes, "a dagger straight into the heart of the climate change religion," with a list of 31 regulations to be scaled back or eliminated. One of the most consequential actions, it was said, would, quotes, "see the EPA reconsider a landmark 2009 finding that greenhouse gases harm human health, which has been used to underpin laws aimed at addressing the climate crisis." Now, as you probably know, that is a reference to the EPA's, quotes, "endangerment finding under the Obama administration following the great case of Massachusetts against the EPA in 2007. That was when the Supreme Court, noting the then undisputed evidence of the threat of climate change, held by a majority that the EPA's duties under the Clean Air Act included a duty to regulate greenhouse gas emissions from cars, and that its failure to do so was, quotes, "arbitrary and capricious and therefore unlawful." As it turned out, that decision was crucial not only for President Obama's efforts to reform US law internally, but also for his championing of the international efforts which led to what became the Paris Agreement in 2015. Now, of course, it would be wonderful if the EPA team, when they do their review, are able to discover that actually greenhouse gases are entirely harmless and our worries are groundless. Optimists among us, like Joanna, are hoping that's what's going to happen. But sadly, whatever Mr. Zeldin may say or hope, the scientific basis of that endangerment finding has never been disputed in the courts, even in cases to which the last Trump administration was a party. Thus, in the Juliana case from Oregon, which reached the Court of Appeal for the Ninth Circuit in 2019, in the time of the first Trump administration, a group of young people were challenging the government's failure to take action to protect them against the effects of climate change. Although the majority decided that they had no constitutional power to make the order sought against the government, there had been no attempt to question the factual basis of the case. This was put most vividly in the dissenting judgment of Judge Staton. she said this: "In these proceedings, the government accepts as fact that the United States has reached a tipping point, crying out for a concerted response, yet presses ahead toward calamity. It's as if an asteroid were barreling toward Earth and the government decided to shut down our only defences. Seeking to quash this suit, the government bluntly insists that it has the absolute and unreviewable power to destroy the nation." Now that's pretty strong words coming from a Court of Appeal judge, and that was undisputed evidence in that court. So we will watch with interest Mr. Zeldin's attempts to turn the clock back, and it remains to be seen how the courts will respond to the challenges which there will undoubtedly be. I may be naive, but optimistic as ever. I am hopeful that US courts will find it hard to accept that the EPA, as a statutory body, can lawfully adopt an approach that flies in the face of all scientific reality. Now, at this point, I should confess that I have form with Breitbart News, as some of you may remember. Indeed, they probably have me down as one of the, quotes, leftist environmentalist radicals they are so concerned to bring down. I first came aware of Breitbart News, led by one Steve Bannon, back in 2015, when I helped to organise an international conference on climate change and the courts. That was organised by the Supreme Court in conjunction with the Foreign Office in King's College London, with support from UNEP and the Asian Development Bank, and a number of people who were at that conference, including Brian Preston and Luke Laverizon here, were at that session. The object ahead of the Paris conference later that year was to assemble a group of specialist judges from a number of different countries around the world, together with practitioners and academics, to look at the legal issues arising from climate change and the role of the courts, national and international. The conference included a public lecture at the Supreme Court by Professor Philippe Sands, QC, viewable online through our website. He looked at the possible role of international law and the ICJ in defining the legal obligations of nation-states in respect of climate change. Shortly afterwards, I learned from our press office that the lecture had been picked up by an American news organization called Breitbart News. The burden of the article was I and my fellow judges were scheming to, quote, close the argument forever using the sledgehammer instrument of the International Court of Justice, thus leading to, quotes, an effective global ban on so-called climate change. And the Breitbart article concluded with the comment, Sands is a dangerous man, even more so the man who instigated the conference, a hitherto obscure activist judge called Lord Carnwath. I mean, at the time, unfortunately, my colleagues didn't take it too seriously, and it got me a bit of street cred in the environmental movement, and he even got me an interview with Joshua Rosenberg on Law in Action. But I little thought that 10 years later, Breitbart News would represent the prevailing orthodoxy in US government circles. But optimism is the word of today. So looking back, I think 2015 was a year of great optimism for environment and environmental lawyers. For me personally, our 2015 conference was a very important stage in the development of my involvement with environmental law and environmental judges internationally. That had begun in 2003 when I was in the Court of Appeal, and I was asked by the then Lord Chief Justice, Lord Wolfe, to represent the UK judiciary on a judicial task force set up by UNEP, based in Nairobi, to oversee the development of an international program of training in environmental law. And it was there that I met a number of the judges from different parts of the world with whom I've worked ever since. One important part of the program was to develop judicial cooperation on a regional basis. And in 2004, I was one of a group of European judges, including Luke Laverizon, who's very kindly come from Belgium, from his busy responsibilities in the Belgian Constitutional Court, which he's president here today. And that's when we got going back in 2004. And we established what was called the EU Forum of Judges for the Environment, or EUFJA, to to exchange knowledge and ideas on the practical application of the environmental law within the European community. And I remember very well Luke telling us that we should register it in Belgium because it was so much easier to do there, which I think turned out to be right. Happily, our membership has survived, the UK's membership has survived Brexit. There was, I think, Luke was able to change the rules so that former European countries qualified. And Lord Justice Keith Lindblom, who's here today, remains an active member of the committee, and a few years ago hosted a conference in Oxford. And in September last year we celebrated its 20th anniversary with a conference in Budapest, still under Luke's leadership. Now in 2012 I joined the Supreme Court, but I was still allowed some latitude in speaking at conferences around the world, mainly on environmental law issues. And in October 2014, I was fortunate to be invited by the Sultan of Perak to speak in Kuala Lumpur on the topic environmental law in a global society. And this was part of a series of annual lectures by senior common law judges arranged by the Sultan in memory of his father, Sultan Azlan Shah, former Chief Justice of Malaysia. It was a very jolly occasion. He was a very good host, the Sultan of Perak, as you might expect, but he was also very keen on karaoke. So that at a restaurant dinner after the lecture, I found myself with Bambina, my wife, who was here, singing a duet version of Bésame Mucho. But I think my lecture was more successful than the duet. And anyway, it gave me a chance, actually, to review the sort of development of environmental law over 100 years, going back to the efforts of the courts here in the 19th century to cope with the effects of the Industrial Revolution, and then coming forward to the more recently to the UN developments such as the Stockholm Conference in '72 and the Rio Conference in '92. And I ended by referring to the challenge of climate change and the hopes that the law would be able to provide a bridge between the science and effective political action. And so it was really to give substance to that idea that we promoted the conference on climate change and the law in 2015. Now, as it turned out, 2015 was a very good year for climate change case law. In the months before our conference, there were two important judicial developments from very different legal systems. The Urgenda case in the Hague District Court in the Netherlands and the Leghari case from the Lahore High Court in Pakistan. And we had judges from both courts at our conference, and they spoke of how they had been able to develop the law in those two different legal systems. And in both, the national courts upheld challenges to their government's failures to implement effective policies to counter climate change. Well, then, of course, later that year, we had the Paris Conference and the Paris Agreement of December 2015, which was, of course, a truly monumental achievement. And I remember visiting Paris briefly during the conference period for a side event on the role of the courts. And I was struck first by the sheer scale of the operation. And it's also easy to forget now that it came only 2 weeks after the unprecedented terrorist atrocities at the Bataclan Theatre in Paris, which led to 130 deaths. And that had raised doubts as to whether the conference could go ahead at all. And yet, in spite of that, it was an amazingly sort of relaxed occasion, very well organized, and over 150 heads of state gathered on the very first day of COP. And I think it was probably the fresh memory of those terrible events that helped to concentrate the minds of the participants and made failure unthinkable. Now, I'm not going to go into the details of the agreement or what's happened to it since, but as far as I was concerned, I continued to be involved in exchanges with environmental judges across the world with the active support of UNEP and other agencies. And I particularly enjoyed meeting other common law judges at conferences of the Commonwealth Magistrates and Judges Association and the Commonwealth Law Association, and discovering common ground in our approaches to the protection of the environment. And then in 2018, at a conference in Brasilia, hosted by Judge Antonio Benjamin, who I think may be listening to us online from Brazil, we established the Global Judges Institute on the Environment, which has again continued to promote judicial cooperation around the world. And he has been and remains one of the most active champions of environmental law and judicial cooperation around the world. Now, I wouldn't like to leave the impression that I spent all my time at the Supreme Court travelling the world to conferences in exotic places. They were very nice to me, but they did expect me to do some work in London. And in fact, Preston has very kindly reviewed some of my judgments on environmental themes in the UK courts, and I think his paper will be on the line. But I'm going to mention one case, again from 2015, which had particular significance for various reasons. In April that year, I gave the lead judgment in a case in which Client Earth was seeking to force the government to comply with the legal limits set by European directives for nitrogen dioxide concentration in the air. Since the deadline for compliance had passed in 2010, the evidence showed illegal concentrations in 40 out of 43 reporting zones. So the issue was not so much about compliance, but what the court, as opposed to the European Commission, could or should do about it. It seemed to me important that we should make an order with real teeth, and my colleagues agreed. And to do that, we not only made a mandatory order requiring the government to prepare revised plans by the end of the year, but we gave Client Earth liberty to apply to the administrative court for any supplementary orders required. And that led to 2 subsequent applications to the administrative court, resulting in further orders for improved plans. Now, apart from the importance of the case for what it decided, it was through that case that I came to know about Client Earth and their extraordinary campaigning work around the world, including in China, as I'll come to. I later met its founder, James Thornton, who has since become a good friend. And of course, since I left the Supreme Court in 2020, I've been much freer to work with organisations like Client Earth on some of their cases, and also to follow up what had happened to that particular case. And one of the problems of being a judge is you decide cases, and then you never know what happens afterwards. But in this case, I was lucky enough to make contact with someone called Katie Neild, who I don't think is here, but she was working with Client Earth and was responsible between 2018 and 2024 for monitoring the government's compliance and bringing pressure and maintaining pressure. And it's a very interesting story, and she's written, I've seen an article which is going to be in the Journal of Planning and Environmental Law, which describes the progress under our order and how Client Earth were able to keep the pressure on. And it does give a fascinating insight into the challenges of turning a court victory, which is one thing, into successful action on the ground. Now, also, since I left the Supreme Court, I've been lucky enough to develop strong links with the academic environmental community, especially with the Grantham Institute here, but also with the environmental law departments at UCL and Oxford. And one of the things I found really interesting is actually being able to go to seminars in Oxford and UCL and meet a sort of new generation of environmental law students and discuss cases with them. And often they're my own cases, which they're not always as flattering about as perhaps I would like. But it's certainly interesting to get different views. And I've also, through Grantham, been kept up to date with developing case law in this country and around the world. Now, there's not time and it's not the place to look at cases generally, But I will touch on what for me has been one of the most important and encouraging developments over my time in the law. That is the growing and now almost universal recognition of the environment as requiring constitutional protection, whether or not explicitly covered. Because the constitutions or human rights instruments, such as the European Convention from earlier periods, make no explicit reference to the environment. But from the 1990s, some courts, led by the Indian Supreme Court, began to interpret general guarantees of the right to life as including the right to a healthy environment in which to live. And similarly, the Supreme Court of Pakistan in 1994 held that life did not mean just, quotes, vegetative or animal life or mere existence from conception to death, but includes all such amenities and facilities which a person born in a free country is entitled to enjoy with dignity legally and constitutionally. And I particularly liked the approach of the Philippine Supreme Court in 1993 in the famous Opposer case. They described rights to a balanced and healthful ecology as basic rights which predate all governments and constitutions and need not be written in the Constitution, for they are soon to exist from the inception of mankind. And that court memorably upheld a challenge to the state's policies for granting consents to fell in the country's virgin forests, in a case brought by some 43 children from all over the Philippines on behalf of themselves and, quotes, generations yet unborn. And more recently, in the climate seniors case in the European Court of Human Rights, the European Court went down the same route. That was a case brought not by a group of young children, as most of these cases are, but by a group of senior women for climate protection from Switzerland. I was quite pleased that the elder generation were for once represented in a case. Anyway, they were successful. They alleged that the Swiss government had failed to uphold obligations under the Swiss Constitution and the European Convention by not adopting effective policies to achieve an emissions reduction consistent with the Paris Agreement. And the Grand Chamber upheld the case. They found that Article 8 of the Convention, which deals with the right to respect to the home and family life, encompasses a right to effective protection for individuals by state authorities from the serious adverse effects of climate change on their lives. Now, some have criticized this decision as an inappropriate extension of the Convention to subjects which were never in the contemplation of the original parties. And that's probably right. I don't think the authors of the Convention in 1948 were thinking about the environment. But I don't share their concerns. It seems to me there's no practical harm and much good in the judicial extension of the Convention to encompass rights which have long been accepted by judges around the world as fundamental to human existence. Now, against that background, I returned to China. Now, as it happened, my first visit to the Supreme People's Court in China was in 2014, at a time when the development of the environmental courts was just getting underway. It was actually a happy coincidence. My choir, the Bach Choir, was touring China and Hong Kong in the 2 weeks before Easter that year. I was keen to join them, but I needed a credible excuse for a short absence from the Supreme Court. Luckily, my good friend, Professor Hazel Gen from UCL, was looking for an opportunity to organize a lecture by a senior UK judge in their associated university in Beijing. And the Foreign Office were also interested at the time in fostering links with the courts in Beijing. Thus, I found myself on a somewhat schizophrenic trip, singing the Brahms Requiem in Shanghai and Hangzhou, and in Beijing discussing with the Supreme People's Court their plans for the new environmental jurisdiction. It was I didn't know when I was going there that it actually was really a very important time for the development of environmental law in China, and it was very interesting discussing with the judges from the Supreme People's Court their plans for developing their new jurisdiction. And it wasn't really until I got to know Dimitri Deboer and his links with China that I realized how much was going on. And it is an extraordinary feature that the Supreme People's Court turned to client earth to help them develop their new environmental jurisdiction and environmental litigation. And it's, I'd be lovely to hear Dimitri talk about that, and I'm hoping we'll be able to write an article on it in the here, because there's a lot to be said. But I asked him to give me a short account of some of the main achievements, and I can't really do better than just quote a few paragraphs of what he said. A little over 10 years ago, in 2014, China's Supreme People's Court established an environmental tribunal and instructed lower-level courts to do the same. Within a year, there were over 700 environmental tribunals in China, and thousands of judges started to specialize in environmental adjudication. The context of this was a public outcry around 2013, soon after China started to disclose real-time air quality information, which was suddenly available in convenient mobile applications for all citizens. The pollution was so severe it shocked society, triggering a wave of environmental consciousness. Over the past 10 years, the Supreme People's Court supported the establishment of environmental tribunals at all levels and rolled out a series of judicial interpretations for all types of environmental cases. Over 30 environmental laws and regulations have been revised or newly issued. By now, China has easily the largest specialized environmental court system in the world. All of those efforts appear to be paying off. The ramping up of environmental governance and law enforcement in China has been transformational. Results are visible, with air, water and soil pollution much reduced, ecosystems enjoying much better protection, and a cultural shift towards government and business compliance with environmental laws. But as he says, of course, more needs to be done, especially on controlling greenhouse gas emissions. But as he says, it's very hopeful to see the world's largest developing economy prioritizing environmental governance, which matters not just for China, but also for the development pathway and green transition of other countries around the world, considering China's massive overseas trade and investment. So, extraordinarily enough, one finds oneself putting forward China as showing the way on environmental law, while on the other side of the world, the USA seems to be going in the opposite direction. Anyway, I'll end by reminding us of the words of Sir David Attenborough in his address to the UN Security Council in February 2021, and that was into the COVID period. And he said this: perhaps the most significant lesson brought by these last 12 months has been that we are no longer separate nations, each best served by looking after our own needs and security. We are a single truly global species whose greatest threats are shared and whose security must ultimately come from acting together in the interests of us all. Climate change is a threat to global security that can only be dealt with by unparalleled levels of global cooperation. It will compel us to question our economic models and where we place value, invent entirely new industries, recognize the moral responsibility that welfare nations have to the rest of the world, and put a value on nature that goes far beyond money. That was well said. And remembering that this is all about my 80th birthday, I had a birthday, well, I had 3 80th birthday cakes actually over the last 2 weeks as a result of my fan being very generous. But they told me that I had to make a wish as I was cutting my birthday cake. And that was easy. My birthday wish was that the whole world, including the USA, will come back to recognize the truth of Sir David's statement and the desperate need to act on it urgently. And in spite of everything, Joanna, I remain optimistic that my birthday wish will come true. Thank you.
Thank you very much, Robert. And so the plan now is that we're going to hear Justice Preston reflect upon some of Robert's most important decisions, and then we'll soon open to questions. So please, Brian, over to you.
I have written a paper which will be, I think, uploaded and available. It's a fulsome tribute to Lord Carnwath's significant contributions to the development of planning and environmental law. After hearing Lord Carnwath's speech, I thought I should start now saying the hitherto obscure but now outed judge, Lord Carnwath, has contributed materially to the development of not only planning and environmental law, but also governance of planning and environmental systems. In the paper and in the short time that I have in the oral address, I'll address the contributions that he has made during his time as a judge. Now, these contributions are in two categories: judicial decision-making and judicial capacity building. Both concern the development of rules of substantive and procedural law that constitute planning and environmental law, as well as the rules for the adjudication of planning and environmental disputes. In the first category, as judicial decision-making, Lord Carnwath's judicial decisions resolving planning and environmental laws identify and explicate the legal rules that are applicable in the relevant jurisdiction. In the second category of judicial capacity building, Lord Carnwath has built judicial capacity through the provision of training materials and instruction on the legal rules that are applicable to resolving planning and environmental disputes throughout the world. In the paper and in my oral remarks, I'll focus on Lord Carnwath's contributions in judicial decision-making. Now, to be manageable, my discussion of Lord Carnwath's judicial decisions needs to be set in an analytical framework. The framework I will use to illustrate his contribution to the doctrinal development of planning environmental law is the taxonomy of legal rules that make up the body of planning and environmental rules. These rules might be termed interactional rules. They take two forms: rules of competence, which enable the exercise of power, and rules of limitation, which control the exercise of power. Lord Carnwath has developed jurisprudence on rules of competence and rules of limitation in planning and environmental law. But in doing so, Lord Carnwath has also contributed to an understanding of governance rules and how they interact with the rules of planning and environmental law. The rules of planning and environmental law serve instrumental purposes. They enable and regulate governance of the planning and environmental systems. These systems form part of the institutional framework for the governance of the polity and the functioning of society. The governance of these systems depends on constitutional principles such as the separation of powers and the rule of law. Governance rules frame the authority and operation of the institutions in each branch of government to enable good governance. In short, governance rules make the planning and environmental systems work in practice. Hence, although my central focus is on his doctrinal development of rules of competence and limitation, in doing so, I will explain how he has employed governance rules to make the planning and environmental systems work in practice. Now, the structure of the paper and my oral remarks is as follows. In the second and third parts, I survey Lord Carnwath's doctrinal development of both rules of competence and rules of limitation. The fourth part seeks to set this doctrinal development of planning and environmental law in the context of what it means to adjudicate well. I use 4 criteria for evaluating the quality of adjudication of planning and environmental disputes. The first and second criteria relate to the nature of adjudication. both the dispute resolution function and the expository justice function. The third relates to the role of legal reasoning in maintaining the stability of the legal system. And the fourth relates to the need for responsive environmental adjudication. Recourse to these four criteria demonstrates that Lord Carnwath has shown in practice how to adjudicate planning and environmental cases well. In these ways, Lord Carnwath has contributed greatly to planning and environmental law and governance. Let me start with rules of competence. As I said, rules of competence recognise and enable the exercise of power, both public power and private power. The public power may be recognised by constitutions and statutes as well as by the royal prerogative. Private power may be recognised by legislation or the common law. Rules of competence may also confer power on institutions, including courts. So rules of competence vest in courts the power to hear and determine disputes arising under public and private laws and to grant remedies for breaches of laws. Rules of competence may establish and empower specialist courts or tribunals to adjudicate planning and environmental disputes, the so-called environmental courts and tribunals. So let me start with public rights. Illustrative of the public right cases are two cases dealing with the public's right to use public land for recreational purposes. They are the Barkers case and the New Haven Port case. These cases concern a rule of competence. What right does the public have to use public land for recreational purposes, and in what circumstances does the right arise? You'll have to read the paper to find out the answer to the question. Let me now turn to private rights. So in a series of speeches and articles, Lord Carnwath has addressed the increasing role of human rights in environmental protection. It was the topic again of tonight's address. Now, laws granting individuals rights in relation to the environment are rules of competence. The right holders have power to require others, whether they be government or private actors, to respect, protect and fulfil their rights. And in the speeches, including tonight, there was an unpacking of the right to a healthy environment. But a procedural right that Lord Carnwath has addressed in his judicial decisions, as well as his speeches, is the procedural right to effective access to judicial and administrative proceedings to enforce other procedural and substantive rights. Now, that right is one of the three procedural rights recognised by Principle 10 of the Rio Declaration on the Environment and Development, and also in the Aarhus Convention. This procedural right was considered in the Edwards case, in particular in relation to the requirement that the public would be able to challenge environmental decisions in proceedings which are not prohibitively expensive. Lord Carnwath's discussion in the Edwards case is instructive. He has also addressed that question in a number of his speeches. He made, in one of the speeches in 2004, two suggestions to address the problem of prohibitive costs of litigation. First, he said, greater use should be made by courts of the judicial discretion to make no order for costs in cases where the issue is one of general public importance. Second, courts should make greater use of preemptive orders, as public interest litigants need to know in advance what their costs liability is likely to be. Now, these suggestions reveal Lord Carnwath's concern to make the planning and environmental systems work as intended. Crucial to the design of modern planning and environmental systems is public participation in decision-making and governance. As Principle 10 of the Rio Declaration emphasises, environmental issues are best handled with the participation of all concerned citizens. Effective public participation is facilitated by access to information, as well as notification and invitation to participate. But there must also be access to the courts to enforce compliance with these procedural rights, as well as with the law regulating decision-making and governance. So Lord Carnwath's decisions and speeches recognise the importance of upholding all three procedural rights. I turn to the institutional powers of the courts, another rule of competence. And this concerns the institutional powers of courts to make remedial orders. In the paper, I also consider the Client Earth case that was being addressed tonight by Lord Carnwath. In his extra-judicial speeches, Lord Carnwath has referred to both earlier decisions of UK courts, such as in the Birmingham Corporation case, but also orders of the Supreme Courts of India and the Philippines to make a continuing mandamus. So I'll now turn to the rules of limitation. Now, planning and environmental laws limit proprietary rights to use the environment by specifying what activities are permitted or prohibited, what procedures need to be followed to obtain approval to undertake permissible activities, what objectives are to be achieved, and what methodology must be adopted by the administrative decision maker in making a decision to approve activities, and what action may be taken to enforce any breach of obligation. Now, rules of limitation can be subdivided into various categories, and I term these regulatory, liability and market rules, methodological rules, normative and strategic rules, and planning rules. I explain each of those in the paper. I'll just turn to some of those. So, starting with regulatory rules, and in particular regulatory rules in relation to nuisance. So Lord Carnwath has adjudicated on the positive duty of landowners not to cause a nuisance. This is a regulatory rule of limitation, and two cases are of note: the Biffa case concerning nuisance by smell, and the Lawrence case concerning nuisance by noise. Of importance in the discussion in both of those cases is the sort of discussion and reconciliation of the relationship between nuisance law and statutory planning and environmental law. I think I'll just compare that bit. So, in both cases, Lord Carnwath's reasoning has explained that interrelationship and reconciled that conflict between the regulatory and liability rules of the common law, the law of nuisance, and of statutory law, planning and environmental law. This allows citizens and the state to order their relations and behaviour in accordance with the rules of limitation, and thereby make the planning and environmental systems as a whole work effectively and efficiently. I turn to methodological rules of planning. So Lord Carnwath has long been concerned about the methodological approach that ought to be used in interpreting and applying policies of government, especially planning policies. He, of course, practiced extensively at the bar in planning law and has an abiding interest in ensuring that the planning system works efficiently and effectively. Three cases are of note. In 2017, in the Hopkins Holmes case, Lord Carnwath gave the lead judgment for the Supreme Court, interpreting and saying how it should be interpreted the National Planning Policy Framework. Lord Carnwath noted the correct approach to the interpretation of a statutory development plan was as discussed by Lord Reid in the Tesco Stores and Dundee City Council case. However, Lord Carnwath added three qualifications to that approach. The first was that the terms of the policy under consideration are relevant. The second is that in interpreting policies, the court should respect the expertise of specialist planning inspectors and start at least from the presumption that they will have understood the policy framework correctly. And third, he emphasised the need to distinguish clearly between issues of interpretation of policy, which is appropriate for judicial analysis, and issues of judgment in the application of that policy, which are not, and not to ally the two. In 2018, in the Bosong Development and United Basalt Products case, sitting in the Privy Council on an appeal from the Supreme Court of Mauritius, Lord Carnwath applied the interpretive approach of Lord Reid in Tesco supermarkets. In 2020, the question of how to interpret the MPPF arose again in the Samuel Smith Old Brewery, Tadcaster and North Yorkshire County Council case. Again, at issue was the interpretation of the MPPF. Now, these decisions concerning the interpretation of planning policies, they concern that interpretation of planning policies, but Lord Carnwath has also expounded a similar approach to the interpretation of planning permissions. And the case I would refer to is the Trump International Golf Club Scotland and Scottish ministers. That man appears again. So another methodological rule that Lord Carnwath has considered is the duty on local planning authorities to give reasons for their decision to grant planning permissions and the standard of these reasons. This issue arose in the CPRE Kent case. And in that case, Lord Carnwath determined the local authority had failed to provide adequate reasons for planning permission in breach of two duties, one statutory and the other common law. The statutory arose under the EIA regulations and the EIA directive. But Lord Carnwath also discussed whether there's a common law duty on a planning authority to give reasons for a grant of planning permission. Now, I started with the general proposition that a local planning authority is under no common law duty to give reasons for the grant of planning permission. But Lord Carnwath qualified that general proposition to require the giving of reasons in two situations. First, it's well established that fairness may in some circumstances require it, even in a statutory context in which no express duty is imposed. And second, the common law principle of openness or transparency may require reasons to be given, and he explains that. So Lord Carnwath's explanation of when planning authorities need to give reasons for their decision to grant planning permission and of the standard of those reasons demonstrates his concern to make the planning system work not only efficiently and effectively, but also equitably to achieve fairness for all involved. As I've earlier noted, public participation is a critical feature of the planning system, but it depends on public access to information on decision-making, including reasons for decision. Improving access to and the standard of reasons for decisions enables effective public participation. I'll now touch upon normative and strategic rules of environmental management, and I select two decisions. The first is MOT and the Environment Agency, which involve the interplay and potential conflict between normative rules, rules of environmental management, and rules of protection of an individual's fundamental rights, and that concerned right to fish for salmon. The second case was again an appeal from the in the Privy Council from the Court of Appeal, Trinidad and Tobago, Fishermen and Friends of the Sea, and the Minister for Planning, etc. And that concerned a strategic rule requiring consideration of the polluter pays principle, one of the principles of ecologically sustainable development. Then there are the planning rules, and the political planning rules I want to refer to are the planning rules concerning environmental assessment. So planning environmental laws commonly require assessment of the impact of strategies, policies and plans, which is strategic EIA, as well as of proposed projects or activities, which is, of course, EIA projects. Lord Carnwath has addressed environmental assessment in 4 cases, 2 on strategic environmental assessment and 2 on EIA. So the 2 on strategic EIA are Walton and the Scottish ministers and the Queen Buckinghamshire County Council and the Secretary of State for Transport. Lord Carnwath's considered explanation of strategic environmental assessment in both Walton and the HS2 case have aided understanding of the nature, content and application of strategic environmental assessment. Turning to environmental impact assessment for projects, I refer to 2 cases, Jones and the Mansfield District Council and Champion and North Norfolk District Council. Again, Lord Carnwath's explanation of the EIA process have been instructive in the future application of those rules. That brings me to my conclusion in relation to adjudicating well. So my survey of Lord Carnwath's doctrinal development of planning environmental law reveals a judge concerned with not only adjudicating the case at hand, but also adjudicating that case well. Fisher, Scotford and Barrett identified the need for courts to resolve cases well as an important normative challenge. And they observe that the concept of resolving cases well depends upon three aspects. One is the dispute resolution function, the second is the expository justice function, and the third is the function of legal reasoning in maintaining legal stability. I apply each of those criterion in the paper to evaluate the extent to which the decisions of Lord Carnwath meet those criteria and show adjudicating well. I add a fourth criteria which concerns the responsiveness of the adjudication to the underlying planning or environmental problem that the court is charged with resolving. On this criterion too, Lord Carnwath's decisions can be seen to be responsive to the planning and environmental problems in dispute, and I explain why that is so. So recourse to these four criteria for adjudicating a case well reveals that Lord Carnwath has adjudicated well the planning and environmental cases in each of these four ways. His decisions reveal thoughtful and well-reasoned exercise of legal, intellectual and moral judgment in resolving the case. The result has been the principled development of legal doctrine, the delivery of expository justice and responsiveness to the environmental problems in issue, all whilst maintaining the stability of the legal system. His decisions have facilitated planning environmental systems achieving their intended purposes and functioning effectively, efficiently and equitably. Thus, not only can it be said that Lord Carnwath's life in the law is one well lived so far, it can also be said that his contributions to the law will be long lived. Thank you.
Thank you. Thank you very much, Justice Preston. And we'll open for Q&As. I have some very just a few words. It won't take long, but before the Q&As, I just wanted to say that Robert started saying, giving the context about how this lecture came to be. And yes, it's true, we were in Beijing, and Dimitri was there, and Brian was there, and the 300 judges after the US election. What he didn't mention is that the idea wasn't to have a lecture. We were simply talking about his birthday. And he said, well, actually, rather than a party, I preferred a lecture. Now, I know Bambina had a whole plan of parties, and I told him with the lecture part, I can help. So choosing a lecture over a party is, at least to me, perfectly in character for Robert. And since I first met him, he's always struck me as someone who has this deep intellectual and curiosity, always asking questions and eager to learn, interrogate, and understand more. So Brian has dissected all of Robert's contributions. I think probably he knows better now Robert's rulings than Robert himself. But he probably didn't have time to talk about the education work that Robert has contributed to, which is in the paper. So definitely these contributions need to be remembered and celebrated, and this is why we are here with so many of his friends and colleagues from across his career. Now, since Robert had his official retirement, we had the privilege of having him here at the Grantham Institute. But as probably you all know, Robert is anything but retired. He continues to write and travel and learn and also play tennis and golf and sing. So he's been very busy, and we are very happy that and fortunate really, that he has continued to share his time and his wisdom with lawyers and barristers and academics, both of his generation and the new ones. So Robert, I might have tricked you. You know, when I said I wanted you to give a message of hope tonight, well, the truth is that celebrating you and your career, your humility, and your tireless commitment to this field is really what gives us hope. Thank you. Sorry to trick you. Okay. Questions? Sorry. Now, questions. We have not much time, but if you want to ask, please be brief. Press the button just under your microphone, introduce yourself, or just say something to Robert. It doesn't need to be a question. And we'll then head to the reception, which is just outside this room. Monica.
I'm very curious about the life of Robert, not in the law, but the private passions, music. You mentioned Brahms' Requiem in your trip to China. Can you just talk a little bit about what role music has played in your own development as a advocate and then judge in your life?
I'll collect a few more, Robert, if you don't mind. Julia.
Leonelli, LSE, environmental lawyer. So my question is, Lord Carnwath, you mentioned the developments in the intersections between human rights and environmental law as a reason for hope. I have a, perhaps, I don't know, either very traditional or somehow provocative question, which is, I wanted to know your opinion about the limits or misalignment between human rights and environmental protection, not only for the somehow traditional criticisms which have been moved against human rights law-centered cases, such as the normative indeterminacy of the notion of a human right to a healthy environment, the standard of proof, the margins of appreciation for the states, the balancing stage, different systems and different legal cultures. But actually, the point that I really wanted, that I would be very curious to know your opinion about is the foundational objection regarding the tension between individual rights and collective stakes. So when I teach environmental law, I always teach about the case Fadeyeva, where the whole litigation strategy was centered on the resettlement of Ms. Fadeyeva, and that pollution was ultimately regarded as the expression of, in that case, as the expression of a breach of Fadeyeva's right to health at an individual level. And the decision didn't touch upon the rights of the collectivity and how the decision led the community was still harmed and the environment was still harmed long term, regardless of the final findings of the decision. So my question would be, I know that we're witnessing the rise of a new generation of cases. I know that human rights litigation is very different from the old generation. But do you not think that still nowadays judicial review, planning environmental law disputes, even following international law, as Mr. Justice Preston was saying, provides a more promising, more effective way forward to further environmental protection and climate change mitigation?
One last one. It doesn't need to be comment. Question can be comment. Nigel at the back. Yes, press the button. And keep pressing while you speak.
Yeah. First of all, congratulations to Robert on a fantastic, distinguished legal career. Try and keep this brief. There's growing consideration in the light of extreme weather events around the globe. We've only seen this week again South Korea and what's happened there with the fires. There's growing consideration for private tort litigation. to sue for the effects of that around the world. My question is this, and I hope I'm not dropping you in it. How well do you see the UK or the English common law as being set up to deal with such a private law action?
So if you can answer the questions, we might be able to get a second round. So try to be brief.
One round's enough.
There you go.
Thank you. Yes, well, I liked Monica's question, which was all of, I mean, music has been a very important part of my life, and it's been wonderful being able to sort of combine music with the law. Anyone who's interested, we're singing the Matthew Passion at the Festival Hall on Sunday week, and I think there's still tickets, and so we'll be very pleased to see you there. And in fact, when on my trip to Hong Kong and China, we sang the Brahms Requiem in China, and then we went on and sang the Matthew Passion in Hong Kong. But I had to combine them with sort of lectures on the law in both Hong Kong and China, and that was a lovely combination, actually. The other question, I'm afraid I'm not. We can talk afterwards, but my sort of mind stops relating. Once a question goes beyond a couple of sentences, I sort of lose track. And so I'm sorry, I'm not going to attempt to answer it, although I think I would be very interested to develop what you're talking about, but today is not the right time. And as to the other question, which I think is fundamentally important, is how the common law can cope with this. I think it's very interesting to see. One of the reasons I look back at the 19th century cases was the way the courts there struggled to deal with the sort of completely new problems created by the Industrial Revolution. And one sees through the courts developing the sort of nuisance law and other things. And what I thought was a very interesting case, which I didn't mention in New Zealand recently, the Supreme Court there allowed a case to go forward by a group of Maori chief families who were complaining that the carbon majors were polluting the environment. I mean, Brian can talk about this. But the court sort of looked back to the 19th century and said it's only now, then they were sort of grappling with problems of the scale that we're grappling with now, and they thought that the courts would need to develop that. And what's funny is actually the way the Dutch courts seem to have led the world in developing cases both against the state and against Shell and others. So I think we'll see these things developing, but I will not be there to help them forward, but I'm sure plenty of the other people in this room will. So I think that probably is all I can say at this stage.
Yes. Luke, please.
About the human rights approach to environmental protection, you mentioned the Fadayeva case. So that is case law on the basis of the existing European Convention of Human Rights, which does not contain a right to the protection of the healthy environment. So the European Court of Human Rights can only protect the environment indirectly if environmental problems cause infringements of other fundamental rights which are in the convention. For example, the right to life, the right of privacy and family, and so on. So the recognition of a self-standing right to the protection of a healthy environment would protect the environment as such, and that is often the problem, that there is environmental harm, there is environmental destruction, but no one can go to court to enforce to enforce the law. So Ludwig Kramer said courts cannot go, trees cannot go to the court, fish can not to the court. So that would be an additional way to protect the environment, but it does not replace existing planning law, etc. It's a complementary thing. So I see no contradiction between developing planning law, traditional environmental law, permitting, environmental impact assessment, and additionally a self-standing right to the protection of a healthy environment.
Thank you. So I will listen to what Robert said and wrap up here. I want to thank all of you, friends, family, colleagues who came. I want to thank the law school for supporting this. Thank you, David, and the law school for all the support. Thanks also to the whole team from the GRI who helped organizing this. There were hundreds of people who wanted to attend, and we had to say no, no, no. So you're the lucky ones who came in person. And now even luckier that we have a chance to have a drinks reception and chat just outside here. So please join me in thanking the whole panel and especially celebrating Robert.